Good morning, everyone, and welcome to the Read Longyear Summer 2022 webinar on estate planning and related issues. For those of you that have worked with the firm over the years, we appreciate you being here, and those for you that are newer to us, we welcome you and appreciate the opportunity to work with you and your families on these important planning issues. Our topics today range from Washington's death with dignity law to the formalities about what happens after a will signing, committed intimate relationships for couples that are not married but are cohabitating and sharing life together and that sort of thing. And then we'll also be talking about the process of helping another family member or friend purchase a residence and some of the important legal issues that can be identified and addressed in that process to avoid future problems and legal issues down the road. So for those of you, again, that are new to the firm and those of you that have worked with us, as you know, our firm is located in the Norton building. We in downtown Seattle. We focus on estate planning, business planning, real estate related matters, as well as our family law and employment and related services, legal services that we provide. We have a great group of attorneys and staff that are available to answer questions. And for today, there will be a Q&A session at the end of the presentations. And so Zoom allows you to submit those questions. And so we'll be looking for your questions at the end of the presentations. So I have a few minutes before we get started with our first speaker, Carla Calogero. Carla is a graduate of Seattle U Law School. Prior to her going to law school, she also has a degree in bioethics and brings that combination of her interest in the ethical considerations with her estate planning practice, as well as the other work that she does in conservatorship and guardianship and trust and estate planning. So Carla will be talking today about the Death with Dignity Act, and I think I'll let Carla get started because although you have 10 minutes, I'm sure you might be able to use a minute or two more. All right, Carla.
Here I am. Thank you all for being here and joining us again if this is your second time with our webinar series. As Mike said, I'll talk a bit about the Washington Death with Dignity Act today. And also, as Mike said, if you have questions that I hope I can answer, we'll take those at the end of all the presentations in the Q&A. You can enter questions in the chat box, though, throughout the presentations. Washington's Death with Dignity Act was actually a voter initiative, Measure 1000, that was enacted or brought to the legislature by the voters in 2008 and enacted by the legislature in March of 2009. And the act permits qualifying patients to request a physician's order for a lethal dose of medication with the intent to self-administer the medication and cause one's death. Who is a qualifying patient under Death with Dignity? One must be an adult, a Washington resident, under the care of two physicians who are willing to provide the services under the Act. And these physicians are called the attending physician and the consulting physician. And we'll talk more about their roles in a couple of moments. But the patient is charged with identifying a willing attending physician and a willing consulting physician. It may be their primary physician who would serve as the attending, but perhaps not. And then the patient would need to find another primary attending physician and a consulting physician. One must be terminally ill, which is defined under the Act as having an incurable and irreversible disease that will, within reasonable judgment, produce death within 6 months. The terminality, the terminal illness must be confirmed and verified in writing by the attending and consulting physicians. One must be mentally competent. One must be acting voluntarily and be fully informed about the decision that they are making. All of these requirements for competency, voluntariness, and informed decision-making are verified in writing by the attending and consulting physicians. And finally, one must be physically capable of self-administering the lethal medication. So self-administering the lethal medication, which will be in a liquid form when mixed, can be done orally by bringing the liquid to one's mouth and swallowing. But if the patient is not able to swallow, then she can self-administer through a feeding tube or a rectal tube. And the important act there is that the patient must be able to pull the plunger, so to speak, or push the medication in the syringe into the tube. More about the attending physician. The physician has primary responsibility for procedural compliance within the law, primary responsibility for counseling the patients, primary responsibility for documenting all of the patient's requests for death with dying in the medical record. The attending physician will write the prescription for the lethal medication and must submit all of the Department of Health reporting forms, which I'll show you in just a moment. The consulting physician is sort of a crossing the T's and dotting the I's, really does all that the attending physician does in terms of confirming the diagnosis, the prognosis, patient competency, voluntariness, and that the patient is making an informed decision. Either the attending physician or the consulting physician may make a referral to a mental health professional if one or both are concerned about competency or voluntariness of the patient. Then the mental health professional would also be required to do an evaluation and submit another DOH form. What are the procedural requirements under the law? The patient must make the first verbal request for death with dignity to a doctor. This could be to the primary care physician, or it could be to the attending physician that the patient has identified. After the first verbal request, the patient makes a written request for the death with dignity prescription using the Department of Health form with 2 witnesses, and then delivers the form to the attending physician. Then, after 15 days, at least, after the first verbal request, the patient makes a second verbal request to the attending physician. So first verbal request, then a written request with no waiting period after the first verbal request, but then a 15-day waiting period after that written request for the patient to make the second verbal request. This is the DOH patient's request form. I'll just be putting some of these up on the screen as we move through so you can see what these look like, even though we won't go through each of the provisions. After the second oral request, there is a 48-hour waiting period before the attending physician can write the prescription. This means that at least 7 days are required between the first oral request and the physician writing the prescription, plus additional days for the prescription to be compounded and dispensed by a pharmacist. With advanced planning, the pharmacist may be on the ready, but again, that will take some additional day or days for the prescription to be prepared. What is the lethal medication? It is a compounded powder mixture of diazepam, morphine, digoxin, amitriptyline, and phenobarbital that comes in powder form and then must be mixed in liquid before the patient ingests it or self-administered. The prescription must be dispensed by a compounding pharmacy. So these are pharmacies that, mix the drugs together and then provide, it would be a glass vial with the powder mixture. The approximate cost is $850. And the medication, once it's mixed in the liquid, is extremely bitter. That can be difficult for some patients. And then once fully ingested or administered, the medication will cause sleep in 3 to 15 minutes, followed by a coma and death, which may follow moments later or up to several hours later. Where can a patient exercise their rights under death with dignity? This is a question that a patient and loved ones really need to take into consideration well in advance, perhaps even before a patient has made a decision or is just exploring death with dignity. And the reason why is because almost all Washington hospitals and nursing facilities prohibit patients from taking death with dignity medications on their premises and prohibit their healthcare providers from participating in death with dignity on the premises, and sometimes even off the premises, depending on the contract, the employment contracts. Many retirement and continuing care communities prohibit residents from taking death with dignity medications, but not all. And so it's important to ask for the facility's written death with dignity policy well in advance of planning for death with dignity, or perhaps even before joining such a community. What this means is that if an individual is in a hospital or a nursing facility or a continuing care setting or assisted living facility, that there's additional advanced discharge planning that needs to occur and advanced hospice qualification to have the patient be as comfortable as possible at home or elsewhere. So what happens after death with dignity? Well, on the death certificate, by law, participation is not suicide. Participation is not assisted suicide. On the death certificate, the patient's underlying diagnosis will be identified as the cause of death. And the law provides that choosing death with dignity shall not affect life insurance, health insurance, or accident insurance policies or annuities or qualification for health insurance. We've already talked about all of the reporting requirements. Again, the attending physician must send several forms to the Department of Health that the attending physician, the consulting physician, the patient, and potentially a psychiatric consultant has completed. Whoever dispenses the prescription must also submit the pharmacy dispensing form. So it's possible that the attending physician may be able to do that, but more typically it's the pharmacy who's dispensing the medication. Lots on the screen, but just wanted to inform and assure you that there are very strict reporting requirements, and these Department of Health forms really help the attending physician and the consulting physician adhere to the requirements under the law. You can see in the middle of the screen a section on action taken to comply with the law, and we have the first oral request and the date, second oral request, patient's written request, and so forth. Again, just a glance at the consulting physician's compliance form. You'll see at the bottom of this screen, which is also on the attending physician's compliance form, some check boxes for compliance with assessing the patient's mental status. This is the attending physician's after death form, or part of the form. And many clients, many people ask, well, can't I authorize my healthcare agent to exercise my rights under death with dignity? And the answer is no. In fact, under Washington's Power of Attorney Act, there's a specific provision in the law that provides that notwithstanding any provision in the Death with Dignity Act or any provision in a power of attorney, no rights under the act may be exercised through a power of attorney. We can, however, put a provision in our healthcare powers of attorney that doesn't exactly get around this, but endorses the patient's healthcare agent to assist as able under the law in the process. So here is a sample provision, for example, that we could include in a healthcare power of attorney. If I have determined to end my life pursuant to Washington's Death with Dignity Act, exercise my rights under the act, and I am a qualified patient, I request and authorize my agent to support and advocate for me in my exercise of my rights under the act to the fullest extent permitted by the law. So there are many things that the non-patient, family members, the attending physician, other helpers can do in assistance. They can pick up the prescription, they can mix the medication. None of those are prohibited under the law. The Department of Health has reports for each of the years 2009 through 2020. These are some statistics from 2020 report. The average age of a patient who utilizes Death with Dignity is 73. 93% are white or Caucasian. 86% lived west of the Cascades. And these statistics are similar or comparable for prior years. A chart from the DOH website that shows us, even if we can't read all the numbers, that more Washingtonians are participating in Death with Dignity, increasing over the years. The light gray bar is the participants, meaning those who requested the lethal medication and engaged in the process. And the dark gray bar are deaths of those participants, although not all of those deaths are attributable to Death with Dignity. So about just over 300 persons in 2020. There have been efforts to change the law to make it more, to make death with dignity more accessible to qualifying patients. House Bill 1141 was introduced in sessions 2021 and 2022. Unfortunately, or I guess that's my opinion, it didn't make it all the way through the Senate. Had a lot of momentum in the 2021 long session and less in the short session in 2020. Primarily, it would reduce the 15-day waiting period to 72 hours. And it would also authorize an expansion of healthcare providers who could perform the duties that are currently those of the attending or consulting physician. In terms of resources, fantastic, the Gold Star resource for death with dignity information and support in Washington is End of Life Washington. End of Life Washington also provides volunteers who can assist the patient and the loved ones and the physicians in the process. That can take some weight off loved ones and allow them to be with the family. There's no cost for any of End of Life Washington services. And then, as I've already mentioned, there's information forms and reports at the DOH website. Thank you.
Great, Carla, thank you so much. And a very complex but important topic and guiding us through that. For those that may have been asking about the slide deck, that will be available for folks to take a look at after the webinar. And we do plan to post this webinar on our website after we get the program completed. So our next.
I apologize. I didn't realize the share screen was not working.
Yeah.
I'm happy to put the PowerPoint in the chat.
Okay, great. Thank you. Our next speaker is Anton Cauthorn, and Anton is a graduate of University of San Diego Law School and also the University of Washington LLM program in tax. He also teaches estate planning and estate and gift tax at Seattle University Law School, and is a go-to person for complex estate planning, and will be talking to us today, presenting today on what happens after will signing. So Anton.
All right, give me 1 second here. Let me make sure I have my screen properly shared. And Mike, can you confirm, can you see my share screen here?
Yes, I can.
Okay, perfect. Okay, today I'm going to be going over something that's not so much the legal side of how estate planning works, but more looking at what we should do with our documents and what we should do after we sign our estate planning documents. And the reason I want to go into this is because it's something that is really important, because we can have the best documents in the world. However, if no one can find them, if no one knows where they are or what to do with them, they're not going to accomplish our goals. And so I know I only have a short time today, and there's a lot of topics I want to go through, but these are all fairly simple concepts. So I'm going to go through these pretty quick. But as you see here, we've got a number of topics. We're going to be jumping from one to the next here as I run through each of these. And so first, let's go ahead and start with a really basic question of where should we store our estate planning documents after we have signed our estate planning documents? And before we get into that, I want to talk briefly about what happens if we can't find our original documents. And today, most of us do many of our things online. We store many things electronically. They're completely valid. They'll work in an electronic format. One big exception to that is wills. If you do not have your original will, it can cause serious problems when you pass away. And so what I want to show first is, here's what happens if you don't have your original will. Now, if you do have your original will, you can see on the left side of this chart here, it's really easy for us to start a probate. We actually don't even go into court anymore. We submit the wills online with a petition to a judge. We do not have to appear. The judge just reviews the submission we've given to them, and the probate will be started. However, if we can't find the will, if there's no original will, and we can find a copy, we have to go through a different process. The process we have to go through is first, we have to obtain statements from all of the witnesses saying that they believe the copy we have is in fact a copy of the original will. Next, we do the same procedure as before, online submission. However, we have to add an additional thing is we have to schedule a hearing. So the attorney is going to have to appear in front of that judge to discuss the lost will. Next, we're going to have that attorney appear at the hearing. I should say too, when we schedule that hearing, we have to give notice to anybody who's named in that will. So everybody who's named in the will and any intestate heir, any person who would receive if there wasn't a will, also has to be notified of that hearing. So then we have to appear at that hearing. And at that hearing, if somebody wants to contest the will, they can do so, saying it's not a valid copy. Then the attorney is going to have to argue to have that will admitted to the probate. And if the judge agrees, the judge can admit the will. If not, the judge can decide not to admit the will. Now, in most cases, when we have a scanned copy of a will and the attorney says, yes, we kept the original copy, we don't have any issue getting it in. But all these extra steps lead to extra cost and delay in starting a probate. And so it really is important to make sure we hold on to our original wills. Now, that being said, what is the best practice? And so the best practice with wills is to make sure we pick a secure location that we can keep our wills so it's not going to be stolen or lost. But in reality, having a will stolen or having a fire that burns down your will, those are pretty rare occurrences. And if something like that happens, most of the time you can come back in and update. The much more common problem that people have for not having an original will is they throw it away in a paper purge or they completely forget where they put their will. And so it's really important to make sure you store your will not only in a secure location, but a location where your family can find it and where you can find it. Don't put it in one of those places where, we've all done this at some point. You've got something secure and you hide it so well that 5 years down the road, you forget where you put it. So make sure you put this somewhere where you can find it when you need it, and more importantly, where your family can find it if they need it. So where are some of the places we might think about storing a will? Lots of easy examples. If you have a safe at home, that's the best practice. Just put it in the safe at home and make sure your family knows how to get into the safe. If not, they're going to have to get a locksmith to get in after you pass away. Another great location, if you have a fireproof locked file cabinet at home, great location. Regular file cabinets are good too. If you're not worried about theft, you're not worried about fire, make sure you store it in the file cabinet though in a way that you can make sure you know it is an official document. You're not going to throw it away and you won't forget about where it is. You can also do a safety deposit box. These can be a little bit harder to get into due to banking hours and sometimes having to get a court order to open them, but it's also a safe and secure way to store them and a great place to find them. And then finally, lawyers' offices like our office, we can store documents, but it's preferable to keep your own. That way you always have a copy of it. All right, first topic done. Let's jump into the second topic here, the tangible personal property list. So when you sign documents with us, we will always give you a copy of something called a tangible personal property list, which is a list you can make at home and you don't have to come back to us to make. And what this is a list of physical objects, and you can say, I'm going to go ahead and bequest these items to these people, and all you have to do is sign the list and date it for it to be valid. And I just want to go through a couple things about this list so we can talk about what's important to do and what's important not to do on this list. And the first thing I have here is I've got an example of a very simple tangible personal property list. And I've got this one example that I list as bad. It says, my couch shall go to Chris. The problem with this is when we create a list like this, we need to make sure it's specific enough so people will know what it says. And assuming you have more than one couch, we have a question of which couch goes to Chris. And let's say you know more than one Chris. Well, which Chris is this going to? So the really important thing when we're creating these tangible personal property lists is that we have to make sure it's really clear what we state on there. So let's look at the rules for what these lists can do. First off, these are optional. You're not required to create a tangible personal property list. However, you are allowed to do so. So if you want to create a list saying, I want somebody to get my couch, I want somebody to get my car, I want somebody to receive my tools, jewelry, antiques, things like that, we can create a list and put things on there. Again, not required. But the important rules, clearly describe the item so people can't be confused about what it is, clearly the name of the person so it's obvious who it is. And then the big one here is it only applies to physical objects. You cannot put your house on there, even though it's a physical object, you can't include a house, can't put bank accounts or anything like that. Now, the great thing about the list is the only thing you need to do to make it valid is sign it and date it. It doesn't need to be witnessed, it doesn't have to be drafted by an attorney. Final thing on this is make sure you destroy old versions. If there's multiple versions of this, they're undated, it can be really confusing about which one's the valid one. So again, make sure you date it and destroy any old versions of these lists. All right. Next topic. Next topic is your healthcare directive. This is the document that says if you're in a permanently unconscious condition, do you either want to remove extraordinary measures and pass away naturally, or do you want to maintain them? And one question people often have is, should you give this to your doctor? Or should you give it to your family? Very often times your primary care physician will ask you, do you have a healthcare directive? Or if you go in for a surgery, they'll ask you, do you have a copy of this? And the question is, should you give it to them? And the answer is it depends. So when determining whether or not to give your healthcare directive to your doctor or a hospital facility when you're going in for a procedure, you should think through a few things. And the first thing is, what's your preference? Do you want to remove treatment or do you want to maintain treatment? And do you trust your family to carry out your wishes, or do you not trust your family to carry out your wishes? So if your worry is you don't think your family will remove treatment when it should be removed, or you think they're going to remove treatment too early and you want them to follow the directive, give the directive to the doctor, because that'll prevent the family from not carrying out your wishes. Because if the doctor doesn't have it, the family doesn't agree with it, they're not going to give it to the doctor. On the other hand, if you completely trust your family, then you may want to just leave the healthcare directive with your family, because they can then make the choice on when to use that document to either withdraw or maintain treatment. So depending on how much you trust the people that you're leaving that document with will determine whether it should go to the doctor or it should just stay with the family and not with your doctor. All right, next topic real quick here. So what if your family doesn't have your passwords? Well, this is one of the very important things that people need to do after they sign their estate planning documents to make sure we can access anything that's online and electronically. We want to make sure that everybody creates a list of their passwords that they store and that their family knows where it is. There's a lot of problems we can run into if you don't have access to someone's passwords, either after they pass away or if they become incapacitated. And so what we suggest is keeping a really good list of your updated passwords so people can gain access to these things. And one of the biggest things we see is that when people have, say, photos on Google Drive or on Apple's cloud, that those photos can be lost forever. This is one of probably the biggest problems we run into, but there's other things too. Bitcoin can be lost. Other valuable assets can be lost, or it can just be hard to find assets if we don't have those passwords. So what should you do and how should you store those passwords? My personal method is I keep using online password manager to keep all my passwords, which I print out once a month and I put in my safe at home. And on top of that, I make sure that my family has access to my phone and my computer. And so what I do on there is I include my cell phone password and also include my computer login. And once a month, print that thing out, put it in my safe. My family knows how to get into my safe and they can access it that way. I know all of us have different password storing mechanisms, but try to find some way that you can make sure your family knows how to see those passwords and find them in case they need them, because this can be really important if something happens to you. Next quick topic here. What sort of information should we store for our family in case something happens to us? And what we should really look at is creating a list of where all of our important documents are, list out all of our assets and all of our debts. If something happens to you, your family may not know what your assets are. They may not know what to go look out for, and so they may lose some of that value. You know, Bitcoin's a great example. If your family doesn't know you have Bitcoin, they may never find it, and that value may be lost. But it's not just Bitcoin. I had a client a number of years ago whose husband had bought all kinds of tiny parcels of real estate all over the state of Washington, didn't have much value, but she was never told where any of this property was. So when he passed away, unfortunately early, she had to wait for the tax bills to come in to find out all of these different parcels of property he had all over the state. So to help out your family by ahead of time, creating a list of your assets and storing it likely in that same location where you store your password and your other official documents. Now, along with that last topic is make sure you have a conversation with your family about where all of your documents are. Let them know where everything is, let them know how to find them, and also talk about your final wishes. One really important thing is, even if you draft a form that says how you should be buried or cremated and what you want for a funeral, if your family doesn't find that form before they do the burial, funeral, cremation, whatever it is, they may not carry out your wishes. So it's important to have a conversation with your family about what those wishes are, and again, also where the documents are so they can find all of those things to make sure your wishes are carried out. Next, we want to make sure we have a conversation with our agents. Make sure you talk to the people you've named in your documents. Make sure they're willing and able to act. Make sure they know where your documents are and how to access them. And also let them know who to contact if something happens so they can figure out how to use those documents. And then the final thing I'm going to talk about just real quick is how often should you update your documents after you've completed them? And the rule of thumb I would say is look at your documents every 3 to 5 years. It doesn't mean you're going to update them, but look for changed circumstances in your life that may necessitate an update. So births or deaths in the family or divorces. Look at your agents to make sure they're still the right people. Look to see, has your financial situation changed significantly where it may change who your beneficiaries are? Or if you have a new health concern, let's say something's happened and you have some sort of health concern, maybe we should update now to make sure the documents are up to date. So those are the things you should think about. And the last part of this is, I want to talk about, can you update your own documents? And I want to, really emphasize one thing here is do not make handwritten changes on your own documents to update them. This is almost a guaranteed way to start a lawsuit because it's ambiguous of whether or not these are valid changes and people will fight over them. So don't make handwritten changes to your documents. So I really don't advise trying to update your documents on your own, because if the changes are not done properly, you're creating a litigation scenario for your family. And that's undoing the whole purpose of having an estate plan. The reason you put together an estate plan is to make sure your wishes are carried out properly. If you try to do these updates on your own and you make a mistake, now you've undone that purpose and the estate planning documents won't work. So I'll go ahead and stop here. I'm out of time and I will let Mike take back over.
Anton, thank you so much for going through those really important follow-up things after a will is executed and making sure that people know about the document and your intent and those important issues. Our next speaker is Christina Corwin. Christina is the head of our family law group and practices, well, when we say family law, that often means divorce, but it also means collaboration and doing prenuptial, postnuptial, and cohabitation agreements. And Christina is going to be talking about committed intimate relationships, which is a very important concept for all of us in Washington to be familiar with. So Christina?
Can everyone see the slide?
Yes.
Okay, wonderful. Well, it's good to be here this morning, and I know I'm just speaking very briefly on this, and I'm happy to have a more involved conversation with any of you about particular details, but this is just to provide an overview of committed intimate relationships in Washington State. And over the years, I've had many clients who have come to me, unmarried clients who've been surprised to learn that assets they've acquired over a period of time actually might need to be shared. But there's one particular case that happened, maybe 5-6 years ago. An older elderly lady came to me in her 60s, and she had been in a really crummy relationship with a verbal abuse, and she had worked really hard and her partner had not. He was taking advantage of her finances and not really pulling his weight, and she was just disgusted and wanted to get out. But she was very, very shocked to learn that after the 20+ years she had been in this relationship, that the law had evolved and changed, and all of her hard work in terms of gathering assets and investing and making good decisions, that she would have to share all of that, or most of that, with her partner, who she no longer wanted to be partners with. And one of my primary goals is to try to just educate generally that I think it's a good idea if people start to live together, to consider how that financially may impact, and potentially put together some form of financial agreement around what the two parties would like to happen. So the first question is, what are committed intimate relationships? It's a stable, marital-like, but not marital relationship where both parties are aware that they're not married, but they are living together. And there's quite a bit of history of how this law evolved. And these non-marital relationships used to be called meretricious relationships. In the last decade or so, the courts finally caught up with the times and changed the name. So sometimes they're referred to committed intimate relationships, or CIRs for short. So the law has developed in this way in order to protect parties who are living together. They've worked together to kind of build almost a family-like unit. Sometimes there are children involved and part of that relationship. Sometimes there are not. But the court wants to make sure that no party is unjustly enriched at the end of a relationship. And so What that means is that there are community-like principles that are applied at the end of parties who have been involved in a CIR or committed intimate relationship. And so it's similar to divorce, but not exactly like divorce. There are some differences. One big difference is that in a committed intimate relationship, the parties cannot ask each other for spousal support. Sometimes that's called alimony or spousal maintenance, but that's not a request that is a valid request at this point at the end of a committed intimate relationship. And also that there are no attorney fee awards. And so those are the differences now. The law may change over time. And so one of the things, that we encourage people to do, again, at the outset, is to come up with agreements about how they want things to work financially for the two of them, what things are shared, what things are not shared. And I'll get into those details in just a minute. But first, probably most everyone knows Washington State is a community property state. And so what that means is that assets that are acquired during the course of a relationship, so not just a marriage, but a relationship, will be presumed to belong to the community. That means both parties together. And it can include things, and I actually have another slide here. There we go. Include things like income, and income could be salary, bonus income, a lot of RSU type income here in Seattle and Washington, Western Washington. Stock deferred contributions into retirement. Those also that are acquired and earned during the course of the relationship would also come within this community-like property. So most assets that are acquired. So the presumption is similar to under in community property when people are married. The similar idea is that if it's acquired during the course of the relationship, the presumption is that it belongs to both parties together and not to one individual person. Now, there are exceptions to that. One is if there's a gift that is just given to one party and that's kept separate, that typically maintains its separate character. If there is inheritance that's not commingled with other accounts or income, that would normally be kept separate. And any other assets that were acquired prior to the relationship or after the relationship ended, and any growth thereon. So for example, if someone has a piece of real property that they acquired prior to relationship, and there is growth on that, so the property and the growth on that all would be separate property. Usually there are always these gray areas where people can argue otherwise, and that's why, again, it's good to have a contract. But generally speaking, those things are carved out to be separate property. And one question that comes up, well, what if I have a piece of property and I sell that piece of property for another piece of property? Well, as long as there aren't other community type income coming in, then most likely it will maintain its separate character. But that's all. There are a lot of ways to analyze what's separate and what's community like property. So those are some of the things that a court can have within its jurisdiction to make awards to each of the parties to try to make it as fair as possible. And in Washington State, it's an equitable split. So sometimes people think, well, it's at 50-50, and a lot of times it is 50-50, but it's not necessarily. It could be anything, usually up to a 60-40. At the point of going on beyond a 60-40 split, I think judges at our superior court level start to get nervous, and the Court of Appeals may not approve something more than that. But usually we see something equitable between a 50-50 and a 60-40 type range of split of assets. So talking about the committed intimate relationship and how a court determines if there is one, of course, you can imagine there often is a party who would want there to be a community property. A community property principles applied, so they would want a CIR to be found, and oftentimes there's a party who doesn't. And so These arguments can certainly be resolved with a judge, and I'm going to in a minute kind of go through the analysis that a judge will take. But most of the time, these cases do not go to trial. That's not a determination made by a judge, and things get worked out in a mediation setting or in negotiation. But so it's usually kind of splitting the difference because there's always the risk the court could find that there is a committed intimate relationship, and there's a risk for the other party that the court will not find it. So people are negotiating around potential risk of having a court determine yes or no. So in turn, let me go to my next slide here. Oh, before, well, actually, let me go to the next slide. Okay, so these are the factors that a court will weigh in determining whether there's a committed intimate relationship. And there are 5 different factors that, and there's not one single factor that takes precedent over the other. There's one that kind of combines them all together. And then of course, the one thing that we find is that it does need to be a continuous, exclusive cohabitation during the relationship. And so what that can look like is, let me see if I can give a couple different examples. So let's say the parties are living together in a home, but one of the parties goes up to Alaska and fishes during the summer, and that's just part of his or her work. And that period of being away, sometimes it's for several months at a time, the court has found, at least in Washington State, that type of leaving and coming back wouldn't necessarily break up the relationship because it's work related. However, another example, if parties start living together and then one party leaves, gets disgruntled and thinks, oh, I don't want to do this anymore, this is not really working, leaves for a couple months, but then decides, oh, I want to get back together, and comes back into the home, the starting point for that CIR is going to be that second time or third or fourth time. So it has to be continuous. And the courts will look at individual factors that play into each individual matter. So another thing the courts will look at is the duration of the relationship. It could be, a CIR can exist after 3 years, after 5 years, even after a shorter period of time. It just depends on the other factors that play into it. A lot of times, even with a marriage, after parties have been married for a year, a lot of times the courts, or 1 or 2 years, the courts are going to want to put parties back into a position to where they were to begin with. So there could be a similar thinking with a CIR that after maybe 1 year or 2 years, we're really trying to put people back into that same position to where they were financially at the very beginning of the relationship, if that's even possible. But, after 3, 4, 5 years, courts are more likely to find that there's enough of a duration in that relationship. Another factor the courts will weigh is if there's a pooling of resources for joint projects during the relationship. And, sometimes parties will purchase a piece of property together, a home together. Sometimes the parties will have maybe 1 or 2 accounts together. Sometimes clients will sometimes ask me, well, we don't have any joint accounts together. So that must mean that there's not a CIR, and that's not the case. You do not have to have joint accounts together. It's helpful. It's a helpful factor in determining, okay, that there's a pooling of resources, but it's not required. Raising children together could be a reason. Even any concerted effort that's made by the parties. For example, all right, you cover the health insurance and I'll cover the utilities, or we'll share these groceries and you take these costs, I take these costs, or maybe there's no money. Maybe someone's a stay at home and I'm at home providing for the children, taking care of meals, doing the type of work that people do to support at home, and the other person's out working. That also could be considered a pooling of resources. Not everything has to be pooled. There could be a couple things that are pooled. So the court is really looking at where the parties work together to pay for their life together to make it work. The purpose of the relationship will also be something that the court will consider. That's enjoying the benefits similar to marriage, such as companionship, friendship, love, sex, this idea to create a family, mutual support, mutual, financial support, or mutual just emotional support through raising children and getting through life. And one of the things the court may consider is, well, how did the couple present themselves to the rest of the world? Do they act like partners? Did they call themselves partners? Sometimes we see people calling each other even husband and wife. So that certainly would play into a factor the court would consider. Whether or not anything was put into writing. A lot of times parties are trying to qualify for joint health insurance under one of the partners' employers. And so we might find writing about the parties kind of jointly taking advantage of those benefits. So the intent of the parties really is the summary of all of these factors together. Is, was it the intent of the parties to be a couple and to help each other out through life. And so the court will weigh all of those. The one thing I will point out is that there is a statute of limitations. So it's 3 years from the point the parties are no longer in that CIR or in that continuous cohabitation relationship. So something has to be brought before the court prior to that expiration of 3 years. So one of the things that we, to work with this, we look at maybe it's good to have a written agreement. Sometimes these agreements are called cohabitation agreements. Sometimes they're called CIR, committed intimate relationship agreements, although as an attorney's perspective, I don't usually like to admit that there's a CIR, even with the agreement. So oftentimes we'll call those cohabitation agreements, and they're signed by partners who are either planning to live together in the future, or they're already living together and they want to figure out, okay, financially, what's separate, what's community. So all of the assets would be identified in this agreement. And we would say, okay, this is what the parties intend to be theirs together. This is what one party says is her separate, and the other party what her separate is. Sometimes we deal with the residents. Sometimes it's something that's jointly held by both of them equally. Sometimes it's not. Sometimes it's held in proportion to contributions to a down payment or what the parties feel like is fair. It could be a different percentage of ownership. And the one important thing that we have gathered over time is that in order to make these agreements enforceable, we follow the rules of what we would do in a prenuptial agreement or a postnuptial agreement prior to parties being married or after they're married. And so there are procedural requirements. Let's see, here they are. So the first is actually a two-part analysis that the court will make. One is, well, is the agreement fair on its face? And a lot of times agreement is not fair on its face, but we always want to make sure that procedurally we can get through the second prong analysis, is whether or not it's procedurally fair. And so in order to make an agreement procedurally fair, we want to make sure there's a complete disclosure of all assets and all liabilities. We want to make sure that both parties have met with and have the opportunity to consult with independent counsel. Ideally, we like to have a certification signed by both counsel to say, yes, we reviewed Washington law. The party signing this agreement, who I'm representing, fully understands what they're signing. They understand what the default law is in Washington state, and they understand what they're signing that makes it different. And of course, now there's no wedding in this one. So, but we also don't want the agreement to violate public policy. So some of the common provisions that we talk about in an agreement are, and I see them running out of time. So I'll just let you take a quick look at this, but retirement, what to do about a family home, what to do with assets that are community-like assets, what to do in the case of death if one party dies, what happens with some of those community assets, what happens with separate assets. Well, a lot of times that's taken care of with wills, but sometimes parties want to lock down what they would like to happen in the case of death. And then just other particular issues that may come up around income. So I think I better stop talking at this point, but I know that we're having a question and answer session at the end. And so I will turn this back to Mike.
Right. Christina, thank you so much. And all these important issues for couples that are cohabitating or considering cohabitating or getting married, and the types of issues that come up. Our next speakers and final speakers for today are Shane Yelish and Josh Reinertson. And both Shane and Josh are practicing in areas of real estate and business law. And what they're going to be talking about is something I think is particularly relevant to the current situation we find ourselves in Seattle, King County, with how high housing prices, and then the planning considerations when families co-own property, or perhaps parents or grandparents are considering helping the next generation finance a home purchase. So I'll let Shane and Josh get started.
All right, good. Can everybody see that PowerPoint?
Yes.
All right, good. So I think Shane is going to kind of discuss the nuts and bolts of each of these topics, and then I'm going to jump in with some comments on estate planning and kind of tax matters there. So Shane.
Good morning. Thank you, Josh, and thank you, Mike, and thank you everyone for joining us this morning to talk about strategies to help others, whether it be children, grandchildren, family members, close family friends, buy a home. Buying a home can be a challenging undertaking for anyone, especially in a seller-friendly housing market like we've seen over the last couple of years with 20 or 30% price appreciation during the COVID years particularly. There's no doubt about it. House prices are high, rent is high. First-time home buyers especially are particularly challenged in today's real estate market to, one, save for the required down payment, which is typically 20% of the purchase price. If they've got the cash required for the down payment, whether their income meets or qualifies for the mortgage lender's requirements for the purchase prices. And then finally, including purchase offer contingencies, which oftentimes may include a financing contingency in an offer, are often beat out today by all cash or non-contingent offers. So assisting a buyer with the ability to compete with an all cash buyer through a strategy we'll talk about today can be the difference in getting the deal or missing out. And then finally, even if a buyer does satisfy those three criteria and can put the property under contract, it may be tough for them to service the loan at a high leverage situation or high leverage rate, particularly with the rising interest rate environment we're experiencing today. So what are some strategies that we can utilize to assist a buyer in purchasing a home? And typically there's four. You can make an outright gift of cash, or purchase the home and convey the home to the buyer or the child. You can provide a private loan to the buyer, or purchase or co-purchase the home for the use of the buyer. And then finally, the co-signing on the loan along with the buyer. And there's various tax advantages and consequences for each of these choices that need to be carefully considered and structured before just jumping in. And Josh is going to talk a little bit more about that today. So the first kind of strategy would be the outright gift. And this is simply gifting money to the buyer that would allow the buyer an amount to have a sufficient down payment to qualify for financing the purchase of the home. And this amount will make a large, or alternatively, it could make a larger down payment to reduce financing costs from the private mortgage insurer, or avoid mortgage insurance on the private mortgage side, or reduce the monthly payment to a level the buyer can comfortably afford to pay and service the debt each month. And then finally, purchasing the home with cash to avoid bank financing altogether, particularly with the rising interest rates right now, and not being put into a long-term commitment on a 6 or 7% interest rate loan in the next couple of years, would provide a lot of advantage to those buyers to avoid paying a traditional lender a lot of insurance. There are some downsides, certainly with the gifting of the funds, reduction of assets for the party making the gift tax reporting issues, and it also reduces the lifetime gift tax exclusion that the giftor would receive. And so I'll turn it over to Josh to talk a little bit more about the tax consequences of making the gift.
All right, thank you, Shane. So I'm going to provide you with a very condensed overview of the taxes that are relevant to the strategies that Shane is discussing. So the first tax we're concerned about is the gift tax. Washington does not have a gift tax, so it's not necessary to report gifts or pay any gift taxes to the state. However, the federal government does impose a gift tax, which is a flat 40% on the value of the amount gifted, and the person that's making the gift is responsible for reporting and then paying for any gift taxes that are due. Two important exceptions here. First, you can make gifts of up to $16,000 per person per year, tax-free and without having to report the gift to the IRS at all. Married couples in community property states like Washington can gift up to $32,000 per person per year, tax-free. The second important exception is in 2022, each person has a $12 million, it's actually $12,060,000 lifetime credit for gifts that are over and above that $16,000 or $32,000 exclusion. You do have to file a gift tax return if it's over that amount, but typically you're not going to be paying taxes because the exclusion is or the lifetime credit is so generous. The second tax we're concerned about is the estate tax, which is the tax that's payable at death. Washington has its own estate tax, ranges between 10 and 20% of the value of assets that are included in your estate at death. In Washington, each person has a $2,193,000 credit, so that Washington state estate tax doesn't kick in until you're over that amount. The federal government also imposes its own estate tax, a little bit more aggressive. It's a flat 40% tax on the value of assets in your estate at death. However, each person has the same $12,060,000 exemption for gifts, which also applies to their federal estate tax. So the catch here is that the gifts that you report during your life to the IRS reduce the estate tax credit that's available to you at your death for application to the federal estate tax. Kind of importantly, that federal credit's set to drop down to $6 million or somewhere about there at the end of 2025. So you really want to be cognizant of your estate planning when you're considering large gifts. And so what are the tax considerations of gifting cash or a home directly? Well, you do remove the value of that gift from your estate, so you may be reducing your estate tax liability at your death. However, you're going to want to consider how much of your federal estate tax credit you may need for other assets in your estate. Another very important consideration, if you're gifting property directly to children or another party, there's what's called a carryover in tax basis in the property. What this means is that any capital gain that's accrued on the house, but that you haven't recognized because you haven't sold the house yet, your children or whoever you're gifting the house to, they're going to be saddled with that capital gain when they later sell the house. In contrast to this, let's say, for example, you left the house to your children in your will and the ownership only transferred to them at your death. The tax code allows you to eliminate all that capital gain that's accrued prior to your death. So that's an important consideration with gifting. One last point here, there's a real estate excise tax that's imposed on the transfer of homes in Washington. Gifts of houses are exempt, but you still need to file paperwork with the county and the Washington Department of Revenue. Also, if your children are assuming any debt on the house that's being gifted to them, that assumption of debt is subject to the excise tax as well. Shane?
Thanks, Josh. Another strategy that can be utilized is simply a private loan from the grantor to the buyer. Instead of a gift, you make a private loan evidenced by a promissory note, secured by a deed of trust against the residents, like traditional bank financing would. This is similar to, or in addition to, traditional bank financing, but the lender is the family member rather than a traditional bank. The primary benefit to this type of transaction is that the buyer can obtain more favorable loan terms than traditional bank financing. It is important to charge the interest rates required by the applicable federal rate, which is published monthly by the Internal Revenue Service and is kind of the floor of interest rates that are required to be charged without creating or having tax consequences that Josh will talk about more after this. The applicable federal rate for July 2022 is between 2.3% and 3.2%, depending on the length of the term of the loan. So significantly below what market rates right now in the 5% to 6% for traditional bank financing on a residential transaction. This private loan concept can also be utilized when the buyer may not qualify for a commercial loan or is buying or trying to borrow more than they would otherwise qualify. And family members, parents, grandparents may be less likely to foreclose on a property if a default occurs than a commercial lender more willing to work out some solutions. And then this private loan concept can also be used to supplement a commercial loan and subordinate or put the family loan behind the commercial loan. But this also requires participation generally with the commercial lender. Oftentimes the deed of trust language will prohibit additional encumbrances or deed of trusts recorded against the property. It could constitute an event of default. So certainly reviewing the traditional bank financing documents prior to making those loans secured by real property is very important. The downsides could certainly outweigh. In the most recent growth periods, we haven't seen many banks worry about that type, but certainly in the 2008 through 2012 or 2014 period, I ran into a lot of borrowers who maybe were just out of covenant with some of those kind of technical defaults, and oftentimes lenders, if the property was underwater, did not want to allow that loan to continue and called those loans due, which created a lot of problems. So, certainly if we're talking about private loans, when commercial financing is involved, a careful review of the current loan documents is very important to make sure that another loan does not trigger some sort of covenant default. And I'll turn it back to Josh to talk about the tax consequences.
Okay, so as Shane, kind of mentioned and alluded to here, one of the most important things for tax purposes is that the private loan, it should be, a real loan. And I've listed a number of the factors that the IRS looks at when they're determining, the tax characteristics of a loan and how that can affect gift taxes and things like that. Probably the most important factor is charging the correct interest rate, which Shane mentioned, the applicable federal rate. If you forgive any principal on the loan, any interest on the loan, or if you're charging below that applicable federal rate, then that can create a taxable gift in the eyes of the IRS, and you might have to end up paying reporting or paying taxes and potentially penalties on that tax. For estate tax purposes, keep in mind that if you die holding a note as a beneficiary of the debt, that value of the outstanding loan is going to be included in your estate for estate tax purposes, both at the Washington and federal level. And then the other consideration with a private loan is that the interest you receive is taxed at your ordinary income tax rate. If you loan any money that's charged at an interest rate below the AFR, the IRS can actually impute that interest as income to you, and you can end up paying taxes on the income that you didn't actually receive.
The third strategy that can be utilized is basically just purchasing or co-purchasing a property with the family member. Here, the buyer either purchases a percentage of or none of the property, but would have the right to occupy the property. The situation where the purchaser is not the occupier, establishing a rental agreement and having rent paid may or may not be required. So consulting with attorneys and making sure that there's nothing that's going to be triggered there, whether rent is charged or not, is important. When the family member co-purchases the home with a buyer, you've got the buyer who will occupy, but another owner who will not occupy. And so we'll talk about in a little bit agreements with multi-owner properties in terms of who has the right to occupy, how you make decisions with repairs and those types of considerations. And so making sure that all of that is spelled out prior to the time of closing on either the purchase or the co-purchase. And Josh?
Yeah, so what are the gift tax consequences of purchasing, all or part of a home for someone else? In theory, if the person you're gifting the house to is living there and not paying any rent, that could be construed as a gift. But on the other hand, I'm not aware of the IRS ever coming after anybody for that. If you plan to transfer formal ownership of the house to the child or whomever you're gifting the house to at a later point, you want to keep in mind that the value of the gift for tax purposes is measured at the time the gift is actually made. So if the house later increases in value from the time you purchased it for the other person, you may have a larger gift to report. One option here might be to place the home, the residence, into an LLC or another type of entity, and then each year you can gift partial ownership of that LLC or other entity to your children, and each of those values can be under that $16,000 annual exclusion amount, so you avoid tax reporting for the gifts. For estate tax purposes, again, you need to be aware that the value of the portion of the house that you own at the time of your death, that's included for estate tax purposes. If your children are paying rent or the property taxes, that could potentially be construed by the IRS as income that should be taxed. And then also you want to keep in mind that if you buy all or part of that residence for your children or another party, and it's later sold, you might not get the full benefit of the $250,000 capital gain exclusion for primary residences. I think most people are aware of this, but if you live in your primary residence for a certain period of time and use it as your primary residence, if you're a single person, $250,000 of that capital gain is ignored. And then if you're married, there's a $500,000 benefit. Presumably in this sort of case where you're buying a house for a third party, you don't get that exclusion because it's, presumably not your primary residence. And then your children, to the extent they own the property, they would get that exclusion only in proportion to their ownership interest in the property. And then Shane's going to talk about co-signing loans.
And then finally, the concept of a family member may simply co-sign the traditional bank financing promissory note, qualify with the buyer/borrower to allow them to borrow more than they otherwise would be authorized by the lender to borrow. This allows the buyer to obtain a loan the buyer may not otherwise qualify for on the basis of the buyer's own income and assets. The downside to this is the family member bears the risk that the buyer may default on the commercial loan and then be forced either to step into the shoes and satisfy the debt to preserve the equity in the property, or have its co-signing, if there is a deficiency judgment, at risk. So that would be the other consideration there, is if there is the property is foreclosed judicially, at foreclosure, it doesn't accomplish the amount of the debt, the lender can pursue the difference in the foreclosure proceeds versus the amount of the loan against a co-signor. So that is one of the more concerning aspects of co-signing rather than some of the other strategies. And then Josh, are there any tax consequences related to the co-signing?
Not particularly that you need to be concerned about now.
Okay, and I see that we are running a little late. I want to be cognizant of your time, so maybe we'll just spin through these next couple of slides on the co-owning a secondary home rather quickly. With multi-owner residences, there are kind of two structures or strategies that are utilized when more than one party is owning the property. Typically, we recommend a limited liability company that creates limited liability protection for the property owners, particularly if it's going to be a rental, nightly rental, Airbnb, VRBO type thing, where you have guests coming and going. We want to make sure that any potential liability associated with that rental is segregated to the equity in the property only and protected or protect the co-owners other assets. Generally in residential transactions, commercial lenders won't lend to limited liability companies. And so in that circumstance, if you're borrowing funds, if you're leveraging the transaction, we have to take ownership as a tenancy in common and put together a tenancy in common agreement that defines the rights and the uses amongst the co-owners. And so what is a tenancy in common? It's two or more people who co-own a piece of property without a right of survivorship, meaning their ownership passes to their beneficiaries of the will or the trust. And each owner can choose who will inherit his or her ownership interests upon death. We really want to focus on agreements regarding use and how that is divided amongst the co-tenants, who is responsible for the maintenance and the repairs, and who decides when that is necessary. If you're not using the property, can the co-tenant rent it out? And if so, do they obtain or do they receive the rental proceeds, or are those shared? Do those go into a common pool to address other maintenance costs and that sort of thing. And so, when we're talking about these multi-owner residences, we're talking about either vacation properties, family cabins, even investment rental properties. And so there's generally a little bit more risk associated with those types of properties that we want to try and avoid. Finally, when you're putting together these agreements, whether it be an LLC operating agreement or a tenancy in common agreement, people have a tendency to want to avoid the tough conversations. What happens if it doesn't work out, if we can't get along, if we don't agree on, which sofa to buy, or whether the roof needs to be repaired, or if we have an unforeseen expense that one of the parties can't financially accommodate on a second home. How do we address these sorts of things? And consulting with an attorney to get ideas and put those agreements in place before they arise will avoid the disputes. Talking about things when everything is rosy and everyone's excited about the purchase and agreeing on how to handle those is a much easier conversation to have than when after the closing, when people are angry and upset and not on the same page with how to agree, handle these kind of unforeseen circumstances that haven't been addressed. So my recommendation prior to acquiring a multi-owner property, whether it be a family cabin or a rental property or a vacation property, is to consult with an attorney and get that LLC agreement, tenancy in common agreement in writing, and talk about those tougher conversations prior to entering into the transaction, rather after the fact when things is not so exciting.
All right, so I'm going to touch on a few kind of tax and estate planning considerations with LLCs and tenancies in common, and I'll do that real quick so we can wrap up here. If the property's placed in an LLC, that $250,000 or $500,000 capital gain exclusion on a primary residence, it's important to recognize that's lost because the LLC then becomes the owner rather than you and your individual capacity. On the other hand, that might not matter if the residence is a vacation residence, a family cabin, ski condo, or something like that, because that wouldn't be a primary residence that would qualify for that capital gain exclusion anyway. And with the tenancy in common, you could still have that exclusion on your portion of the residence, as long as you're, of course, using that residence as a primary residence. One other important estate planning benefit of an LLC is avoiding an ancillary probate. Typically in Washington, if a Washington resident dies, they have a probate in Washington to administer the estate. However, if there's out of state real property, that property has to be probated in the courts of that state. So for example, if a Washington resident has property in Hawaii, there would be a second probate opened with the Hawaii courts, and that really just kind of increases expenses of administration, and that's something that you generally want to avoid. Having the property in the LLC avoids that second probate because it for reasons I won't get into, it essentially allows the ownership interest to be administered by the Washington court, and thus you're kind of completely avoiding out of state issues. And then with the tenancy in common, you're essentially stuck having that second probate, although there can be some other options available, such as putting into a revocable living trust or something like that to avoid a probate. The other consideration in choosing an LLC between an LLC and a tenancy in common is inclusion in your estate for Washington estate tax purposes. Normally, real estate that's outside of Washington is not included when determining your tax liability. But once you pull that or put that property into an LLC, it actually pulls it into your Washington taxable estate. And so that is kind of a detriment there. Whereas if you live as a tenancy in common, it's more or less completely excluded from your Washington state for tax purposes. So with that, I'll leave it there and turn it over to Mike. Thank you, everyone.
Okay. Josh and Shane, thank you so much for taking us through these important but complex considerations in this type of planning around real estate. And we do have some time for Q&A. There's a few questions in the Q&A box, and one is on making sure that the slides are available. And yes, they are available. Some have been posted in the chat already, or when the webinar is posted on the website, they'll be available. Anton, you were asked about what happens if a gift tax return isn't filed.
Yeah, so if someone doesn't file a gift tax return, for many people, there's no impact for this. And so a gift tax return technically required anytime you make a gift to an individual within a single year that exceeds 16,000. However, there's no penalty for failing to file if taxes aren't due. And the only time someone owes taxes is if they have completely used up their lifetime estate tax exemption, which is currently 12 million. So for most people, if your estate's below 12 million, it doesn't really matter to not file a gift tax return when you make gifts above that amount. Though the exemption is set to drop to 6 million, so it might be that 6 million mark. Now, there is an advantage to filing a gift tax return if you might gift more than that, or if your estate exceeds that amount, which is you lock in the value from a tax standpoint. So if you don't file a gift tax return, the IRS has unlimited time to come back and say, you undervalue these assets, your gift was worth more. Now, if it's cash, it's not going to happen, but if it's something like a house, that might happen. So the only advantage to filing the gift tax return in those cases is that, one, technically it's required, and then two, you can lock in that value. The IRS has a limited time to challenge your valuations.
Great, thank you. Just want to give a big thanks to Attorney Ming Che on organizing the webinar and helping us with all the technical aspects. The other questions on documents being done near a person's death, and that can actually bring in our litigation team who aren't part of this webinar, but I think Anton and Josh and Carla and Shane and I have, and probably Christina as well, have all dealt with those. That we do have these situations where documents are done near date of death, and I'll just kind of answer for the group that they're very fact specific. So there's no one particular answer. Obviously, doing documents ahead of time is the better way, but if things change, documenting the person's capacity, the witnesses, and the types of discussions around the changes. There's a question about whether or not there's a CLE for this program, and unfortunately there's not, but hopefully we'll be able to continue these webinars and offer them to our colleagues and as well as clients. And then there was a question about the Anton and Josh, probably another question for the two of you on the federal lifetime gift credit per donor and per recipient. Is it each child as well as per spouse of a child?
Yeah, I can answer this one. So there's the two different things we talked about here. So the lifetime exemption of 12 million, currently 12 million, that's a per person exemption. So each person has this 12 million exemption. And as you make gifts during your lifetime, it slowly eats away at that. And then when you die, that's whatever's left is the amount you have exempted from estate taxes at death. The 16,000 per person per year is individual in a sense, but it's also based on the beneficiary. So I personally can give up to 16,000 to as many people as I want during a single calendar year. So if I give 16,000 to person A, 16,000 to person B, that's excluded because I gave no more than 16,000 to each person. Then as soon as the calendar rolls over to January 1st, the amount I gave last year completely resets, and I can give those same people 16,000 again the following year. However, if I give any individual more than 16,000, so let's say I give person A 16,001, well, that $1 extra technically has to be filed on a gift tax return and reduces my lifetime exemption. But I can, after that, give 16,000 to a different person, and there's no impact. So it's only once you've given 16,000 or more than 16,000 to an individual and you go over that, that you start eating up that exemption during your lifetime.
And I'll just add for the gifts of real estate, which is a common type of gift that we see, or interest in limited liability companies that we work with clients on. You want to have appraisals and documentation to support that. And then again, a reminder that the current federal estate and gift tax exemptions sunset at the end of 2025. We have a couple more questions here. Recording, yes. So these the program is recorded and will be posted on the website. And again, there's only a federal gift tax. There's no state of Washington. So for gifts of 16,000 in Washington or over that amount, there's no return filed during that person's lifetime. And now we have, it's only the Washington estate tax that comes into play. And I think those are pretty much all of our questions, at least for right now. But again, we welcome you to email us at info@readlongyearlaw.com with any follow-up questions. The program will be posted on the website, and we hope to do another webinar in a few more months. I want to thank all of our presenters for all their time and hard work in putting their programs together. Again, slides will be available, and these are all very general types of advice. So for specific questions or concerns, it's always best to reach out to one of our attorneys directly to schedule a time to talk that through. Okay. And I think that's it for now. Thank you all. And we'll see you soon. And if not, we'll see you in the next webinar. Take care.